My name is Rebecca Thomas. I'm the Head of Employment Policy at the Equality and Human Rights Commission. What I'll do is I will run briefly through what I'm going to be covering this morning, and then we'll just crack on because I know you're probably all desperate for your dinner. Okay, so I'm going to talk very briefly about the role of the Commission, what our status is. I'll look at the current legal framework in relation to intersectionality, and then move on to talk in more detail about the business and ethical case for tackling intersectionality or dual discrimination, and then moving on to good practice with a specific focus on data collection and how to use data in order to inform and drive action. So just briefly, the Commission is an independent statutory body, and we enforce the Equality Act and encourage compliance with the Human Rights Act. We're also an accredited UN A-status human rights institution. We work with a range of different partners and different organisations to influence improvements and drive change, and also look at kind of producing practical resources to encourage improvements in practice. Participation in work is an important aspect of personal fulfilment as well as an economic necessity. And the right to work and to fair working conditions are fundamental human rights. So as a result, one of the Commission's priority aims is around ensuring that people in Britain have equal access to the labour market and are treated fairly at work. So what does the legal framework offer in terms of intersectionality? During debates around equality legislation, way back before the formulation of the Equality Act 2010 and the development of the Equality and Human Rights Commission, there was a lot of debate around understanding that different aspects of individuals' identity can affect their experiences at work, and that there are different implications depending on which grouping of protected characteristics you have. At the moment, both domestic and EU law covers dual discrimination or multiple discrimination, but the protections are weak or currently not in force. So, for example, under the Equality Act, Section 14 would allow individuals who've been treated less favourably due to a combination of characteristics to bring a combined claim. But that has not been implemented, and that's because there was a change of administration back in 2010. The reason it wasn't originally brought into force was that the then Labour government wanted to give employers and organisations time to prepare for the change. Similarly, the EU Equal Treatment Framework calls for states to consider a legal response to multiple discrimination. But actually, recent EU case law has evidence that there's no specific category of intersectional discrimination. Actually, discrimination needs to be proved in relation to each of the protected characteristics that a claim is brought under. This is very much evidenced by long-standing case law in Britain under domestic law. The case of Barr versus the Law Society, which looked particularly at intersectional discrimination in relation to race and gender. Kamlesh Barr was the first female office holder that the Law Society had had. She brought a claim for race and sex discrimination to tribunal, which succeeded, but was overturned at the Employment Appeal Tribunal. That subsequently went to the Court of Appeal, and what they determined was that actually the tribunal needed to have considered each of the protected characteristics separately. So it didn't fail because there isn't a specific protection in relation to intersectional discrimination, but that actually there needs to be very clear evidence across the protected characteristics. And the case I referred to previously at EU law, the Paris case, that was brought on grounds of age and sexual orientation, and the findings were almost identical in that. So, given that we know the legal framework is weak, there is a clear kind of requirement for employers to step up in terms of their understanding and response. In terms of an ethical case for tackling dual discrimination within the workplace and addressing intersectional issues is that everybody should be treated fairly at work. But in order to be treated fairly, we need to have a more nuanced understanding of inequality. And focusing on a single protected characteristic doesn't reveal the kind of structural or systemic inequalities. For example, we know that pay gaps or employment gaps are worse if you are a disabled woman or if you are a young black man. So there is a kind of a real need for employers to understand these barriers and to step up in terms of their responses. We all know the business case in terms of creating an inclusive workforce, so I won't spend too much time on that. But we do know that having a diverse workforce increases productivity, it increases staff commitment, and actually ultimately then the offer to your customer or your client base is hugely enhanced. So, in light of that, what does good practice on the part of employers look like? The Commission has done a range of work on this, and we know that a lot of the practices or approaches that we're advocating here they've been focused on single protected characteristics, we know that actually they bring a benefit across the board to a range of different individuals and different individual experiences. Amongst the types of good practice, having inclusive recruitment practices, that's one of the big ones. You know, having an open and transparent performance management process, having a really good learning and development offer for staff, making sure that there is adequate and effective training in place for managers. One of the big ones for us is flexible working. Flexible working brings so much benefit to the employer and to the employee, obviously. And then equally, you can use approaches such as positive action and apprenticeships to increase a lack of diversity within the workspace. The big one for us in terms of good practice is around using workforce diversity data. That's actually fundamental to being able to develop appropriate interventions and strategies to encourage inclusion and increase diversity. Now, this is because discrimination is a complex topic that can have interlinking causes, and limiting data collection and understanding to single characteristics can fail to tackle those causes. So we need a more nuanced understanding of the barriers people face to enable equal access to the workplace. You know, for example, I've said before, women of colour or those with a disability face even larger pay gaps than women overall. But focusing solely on gender in relation to pay gaps would not evidence the barriers that these particular women face. And we need data on a wider picture to understand the drivers of inequality in these cases. Now, it's clear that data collection enables employers to identify those issues or barriers, recognise the scale of the problem, or understand what's driving it, and enable them to identify actions to address inequalities. Also, and really importantly, use that data to kind of monitor progress. And there is a range of different data that employers have that can be used to drive improvements. You know, looking at recruitment, starting pay, promotion, progression and retention rates, and flexible working take-up. So the issue then, obviously, is what happens when employers get diversity data. One of the things we advocate is action planning. Now, action plans emerge specifically in relation to pay gaps, but we think they provide a real opportunity to employers to set out the steps they're going to take to address workplace inequality, in particular pay gaps, but also the wider drivers. And it also sends out a commitment, a very clear message to employees and suppliers and clients that they are committed to workplace inclusivity, and it can also be used to monitor and assess progress. Now, the government has defined action plans as a document in which the employer has considered their gender pay gap and has offered a next step to implicitly or explicitly reduce or maintain the gender pay gap. We would like that enhanced. We think that could be really, really ramped up. And we would like it to include explicit reference to time-bound and target-driven activities that are based on best practice policy. And we're pushing for these to be mandatory. And this is because we know that some employers are using them, but the quality varies wildly. And we believe that placing a mandatory requirement will increase employer responses to pay gaps or increase effective responses and lead them to take action to address wider workplace inequalities. So, how do we know that action planning works? Well, back in 2018, Centrica, who's one of the companies required to publish their gender pay gap figures, also produced an action plan. And they were really clear. They understood the benefits and the importance of transparency in providing employees with a narrative around why they had a gender pay gap and what they were going to do to address it. So they set out kind of a number of areas. They clarified the difference between the gender pay gap and equal pay. They thought about the employee life cycle through the retention, recruitment and progression. And they also set out specific commitments on a number of areas. As a result of that approach, they clearly evidenced the fact that they needed to consider other intersectional issues. So that has led them to start considering their ethnicity pay gap. Now, at the moment, there is no requirement for organisations to report. The government has consulted on ethnicity pay reporting. But as I've said before, we know that certain groups are disproportionately, affected by unequal pay in the workplace. So we believe this is a really important move, and it will provide a wealth of information and detail to challenge and improve practice and outcomes for employees. So, to summarise, barriers to equal access and inclusion in the workplace, they vary very much on depending on which protected characteristics come into play. And workforce diversity data is crucial to understanding those barriers and can provide the insight needed into intersectional issues. But we need time-bound, target-driven action plans in place to eliminate workplace inequalities. And the Commission is pushing very hard for government to step up and make these mandatory. We're also looking at producing additional resources to support employers and other organisations in addressing inequality and intersectional concerns. So yes, I'll finish there because I know we're tight on time, but thank you very much, and look forward to dealing with any questions shortly. Cheers.